Hello friends, Namaskaram, how are you? Har Har Mahadev, Jai Shiv Shambhu, Jai Mata Di. In today's class, I will discuss the scope of revision. Because many times, whenever you are going to file the revision, you basically avoid the scope of revision. You incorporate not only the factual perspective but also the legal perspective. And when the opposite counsel emphasize on the point that it is beyond the scope of revision in that scenario, you used to get defeated. So, in absence of legal knowledge, the said scenario occurs. So, what we can do, we could understand the concept. So, whenever we are going to contest the revision, we could be succeeded. So, first of all, we have to understand the scope of revision. Regarding revision, two sections are quite important in BNSS. Number one, Section 438. Number two, Section 442. Section 438 is concerned with the power of concerned sessions court regarding revision, while Section 442 deals with the power of Honorable High Court regarding the revision. The inceptory words says, calling for record to exercise the power of revision. Subsection 1 merely says, the High Court or Court of Session may call for and examine the record of any proceeding pending before any inferior court situated within its local or his local jurisdiction for the purpose of satisfying itself or himself. So basically, it is evident that the power of revision could be exercised by Court of Session or by the Honorable High Court. And apart from that, in the revision, the record is to be called for and it is to be examined. But the key point is that the proceeding must be concerned with the inferior criminal court, and apart from that, the court must situate within the local jurisdiction of the concerned sessions court and concerned high court. And whenever the record is called for and it is to be examined, the court has to satisfy that the order is incorrect, the order is illegal, or it is perverse. And if it is found that it is incorrect, illegal, in that scenario, the order could be done accordingly. Means the concerned court either could set aside or quash the order or could remand back the file to decide the concerned application afresh. So the key point is that whenever the proceedings are pending, any order is passed which is intermediary and it is going to compromise your right, in that scenario, the remedy of revision could be availed as per the protocol of BNSS. But basically, we have to emphasize on the legal point so that we could emphasize on the perspective of correctness, legality, and the point of perverse. If we are going to emphasize on the factual score, in that scenario, we could not be succeeded. And apart from that, the court may also stay the execution of any order while exercising the power of revision. And apart from that, if accused is in custody, the bail could be inclined accordingly. But the last protocol is applicable in the circumstances wherein the order is pronounced by the concerned trial court of conviction and against which the appeal has been dismissed. In that scenario, the accused has to file the revision before Honorable High Court. So, if in that scenario the accused is in confinement, the accused could be released on bail subject to execution of bond, which is permissible as per Section 438, subclause 1 of BNSS. So basically, we could simply say that the correctness, legality, and the point of perverse order is quite important, and these are key performance indicator in the application of revisions. For example, if any order is passed by the concerned trial court and there is no reason, it is in limine, it is in short, in that scenario, it is going to violate Section 393 of BNSS, which says that the court is required to specify the reason in its order. So basically, if you observe that the order is in limine and the basic mandate of law is not followed in that scenario, the order could be challenged in revision. So basically, we have to emphasize on the legal point and we have to emphasize the violation. And apart from that, we must understand that the revision would not lie against any order that is interlocutory. So basically, if any order is passed concerning the process, it is not going to compromise the rights of the parties. In that scenario, it will be deemed as interlocutory order. For example, if you submit any application to call for the record and it is dismissed, and it is concerned with the process. In that scenario, it will be the interlocutory order, the revision would not lie. And apart from that, I want to emphasize that, as we know that concerning section 19(1) of CRPC and section 311 of CRPC, Honorable Supreme Court had pronounced a judgment which is cited as 2009 Criminal Reporter page 330. In the concerned case, Honorable Supreme Court observed that no revision would lie against any order passed as per section 19(1) of CRPC and section 311 of CRPC. In nowadays, these sections are correspond to section 94 of BNSS and section 348 of BNSS. So it is quite clear to us, whenever we are going to file the revision, we must understand the scope of the legal position. If we are simply going to avoid the factual score without specifying the legal position, in that scenario we could not be succeeded. So I think that I have clarified you the scope and extent of revision. So whenever we are going to file the revision, just confirm two important facts. Number one, whether the order is interlocutory or intermediary. If the order is interlocutory, do not file any revision, and apart from that, do not emphasize on the factual perspective, emphasize on the legal errors. If there is no legal error in the order, in that scenario you could not be succeeded. So whenever we are going to file the petition, we have to emphasize on the legal score, we have to emphasize on the compliances of section 438 of BNSS, so that we could put up a strong case for revision and could be succeeded accordingly. See you in the next lecture.